I, Eleanor Oliver, read Rosianna Lewis, read Jesse Lee Oliver III, DOC number 109325. I, Eleanor Oliver, disabled, diagnosed with avascular necrosis, mental illness, and heart disease runs through my family. I was assaulted and handcuffed. I've never been late on mortgage or HOA fees in 19 years. Home in Denver area, 80239. Or my taxes, Denver area home, 80207. The pastor of the church, Leo Simmons, dismantled my trailer home in Montgomery, Alabama, 36104. October 219, Denver police and sheriff and some other Caucasian people drilled down my security door at my home in Denver area, 80239. Threw myself, Eleanor Joyce Oliver, and all my items out of my home of 19 years. Snatched cabinets off walls. I, Eleanor Oliver, became homeless. Mother Rosianna Lewis, deceased. Last will and testament changed. All 4 properties sold without my knowledge. Son Jesse Lee Oliver III, DOC number 109325, false imprisonment. Overturned. Posted in Denver Post newspaper. Diagnosed with pink eyes in the Colorado Correctional Facility, Sterling, Colorado. Currently going blind, 2 surgeries until present. He used to be a truck driver. I have documents, receipts, pictures supporting my case. I have been through the chain of command of the Denver, Colorado, and Montgomery, Alabama judicial system. I need help rectifying this horrific travesty that has destroyed my family. Eleanor Joyce Oliver. Results: missing persons, death, murder, false imprisonment, dislocated of my collarbone and elbow bone. The investigator said the police force has a hard-on for my sons, guns pulled on my family, and cars taken. Federal Rule of Civil Procedure, Rule 11, signing pleading motions, any other papers representations to the court sanctions responding party shall have 21 days or 14 days. Moving party may file a reply, date of service. Lesser or greater time as court allows. Understanding 90 days rules, which set forth to all parties being sold without my knowledge. Pursuant to CRCP 24A 1 2B 1 2C. Pursuant to CRCP 65 ESQ. Pursuant to CRCP 13 ESQ for fraud and procuring the debt motion for First Amendment of Rights 15A 1C 1B. To consolidate cases 2012 CV 1932, 2021 CV 33247, 2015 C 68323, pursuant to CRCP 42A contemptuously filed. Councilman Senator Tracy Larkin, deceased, was working with me in Montgomery, Alabama, 36104, and Billy Carter, retired real estate lawyer, was working with me in Montgomery, Alabama, pertaining this case. Pro se pleadings are to be constructed liberally. Haynes versus Creamer, 404 U.S. 519 520 1972. A pro se litigant shall be given a reasonable opportunity to remedy defects in pleading if factual allegations are close to stating a claim for relief. Hall versus Bellman, 935 F2D 1106, 1110 10 CIR 199. FED statute in county court subsequently transferred pursuant to CRC S 136105E. Matters affecting boundaries or title properties. Vanetta Bush Williams changed U.S. mailbox locks. Postmaster gave myself, Eleanor J. Oliver, keys to access my mailbox was tampered with. Identity theft charges, downtown Denver. Reverend Pastor Leo Simmons dismantled my trailer home, Montgomery, Alabama, 36104. Cherry Street, 80207. The defendants here filed a counterclaim, among other things, that the defendant here had initiated unlawful 120 proceedings against property defendant has now. I base my case of Century Mortgage Case number 521-8973 CAL. Venova New Century Mortgage Corporation, case number 521-18973 CAL, CUP, CT, February 18, 2016. Forgery fraud. Homeowners have a legal standing to challenge an assignment of the mortgage loan contract in an action persecuted for the purpose of releasing pursuant to CRS 383519. The recording assignment, whether or not void or not, caused by operation of law, the release or discharge of the lien or deed or of trust. CRS 3835-119. The recording of the assignment, whether void or not, caused by operation of law. The release or discharge of the lien or deed of the trust, CRS 3835-119. Release conveyance executed for the purpose of releasing any or encumbrance against real property was not duly sold under the power of sale. Contained the deed of trust was fraud. Section 113-40104 1F. Those Colorado issues can. Hall versus Bellman, 935 F2D 1106 1110 10th CIR 1991. Dismissal is appropriate only if it appears beyond doubt that the claimant can prove no set of facts of his claim which would entitle him relief. Coney versus Gibson, 355 U.S. 4145 46. 157. Also see Ramirez versus Department of Corrections 222 FD 3D 1238 1240 10th CIR 2000. The court must look the four corners of pleading in question to determine whether a claim is stated. Colorado National Bank versus F.E. Bygert, CO 165, Colorado 78438 P 2D 506 1968. Compliance pursuant to CRCP 121P. Parties did not oppose motion on or about May 11, 2022. Rule 19. Joiner of persons needed for just adjudication. An action, but who ought to be parties. If complete relief is to be accorded between those already parties, shall be summoned to appear in the action if subject to the jurisdiction court. Respond number 474088. Notice of dismissal for failure to prosecute. Alex J. Martinez, Manager of Safety, ex officio, Sheriff, City and County of Denver, State of Colorado. Deputy Sheriff, Sergeant G. Hill, Sergeant Haven was the sergeant in charge at this present time. In 2009, I had 2 surgeries. Christian Wiebert Muller and Graf called me from my hospital bed and harassed me about HOA fees. My doctor then wrote a letter to the Denver judicial system about this matter. In 2010, Christian Wiebert came back while I was recuperating from my 2 surgeries. In 2010, he came back and took my government check out of my account. The Denver Judicial Court had him put it back under Judge McCormick because you cannot sue the government. In 2012 of May, I was sent home by the judicial Denver courts. So Christian Wiebert, Muller and Graf, Westwind Management Group, Inc., to serve myself, Eleanor J. Oliver, correctly. Denver courts gave Christian Wiebert 4 months. September 24th, I returned to the courts. The courts then gave Christian Wiebert, Muller and Graf an extension to October 29th to serve me correctly. I have documents, papers, pictures proving this matter. I have proceeding going through the chain of command since 2008. Governor Hickenlooper, Attorney General Phil Weiser, Wellington Webb, NAACP, Minister's Allowance, Michael Hancock, Tom Martino, and his assistant Clint, Office of Legislator, Office of Judicial Performance. I have documents, pictures, and receipts showing in compliance with CRCP 121 1 through 16 1B of Civil Procedure 121 1 through 15, unless a statute or rule governing the motion provides that it may be filed without notice. Moving counsel shall confer with opposing counsel before filing a motion. The motion shall at the beginning contain a certification that the movant in good faith has conferred with opposing counsel. About the motion, Chase Holding, Inc. is not HOA. Parkfield Masters Association, Inc., a Colorado non-profit corporation, was not my HOA. I, Eleanor Oliver, HOA, paid West Wind Management Group, Inc., address 27 Inverness Drive East, Englewood, Colorado 80112. West Wind Management Group, Inc. was my HOA. Response: Chase Bank has 25 pages of receipts of my resident in the Denver area, Montbello area, 80239. 25 pages of Montgomery, Alabama, my two properties in Montgomery, Alabama, 36104. 25 pages of receipts of that, of which I had been in contact with Senator Representative Tracy Larkin and real estate lawyer Billy Carter of Montgomery, Alabama, about my Montgomery two properties. They were working with me then. Tracy Larkin is now deceased, and Billy Carter, lawyer, is now retired. I still went through the chain of command. Councilwoman DeGette and her assistant Melissa, Topaz McBride, NAACP, Minister's Allowance, Michael Hancock and his assistant, Tom Martino's office, and his assistant Clint, in which July 2019, Tom told myself, Eleanor Joyce Oliver, I do not have to worry about. My house is still in my name. That came from Tom Martino's office, from Clint, his assistant. In August of 2019, Joe Hicks came in my secured backyard of M2 Lending Solutions, walked right in my home, stating that my home has been sold at an auction. Governor Hickenlooper, I went to Governor Hickenlooper, Wellington Webb, Michael Hancock, and his assistant, Attorney General Governor Paulus, and Director of Constituent Service, Attorney General Phil Weiser, and his assistants, Marcus Hill, of which I left handwritten letters to. Governor Jared Paulus. I then went to April and Frank Jones of Colorado Affordable Legal Service, LLC. Frank was rude and disrespectful. April made Frank apologize to myself. Eleanor Joyce Oliver. Councilwoman District 11, Tracy Gilmore, and Assistant Melissa, teamed with Topaz McBride, NAACP Ministers Allowance was at a town meeting in March 12th, 2022, stating they had no idea of this fraudulent behavior from the Colorado judicial system, which was a blatant lie. Willington Webb on Facebook gave Nikita Ricks, of which I emailed Nikita Ricks. He gave Nikita Ricks recognition for passing an important HOA transparency and accountability legislation in the House today, April 23rd, 22. We are thrilled that HB 1137 concerning practices of HOA transparency and accountability passed today, 37 to 27. It is on its way to the Senate. Once passed, HOA will no longer be able to force, close, or for fines. I was never late on my HOA fees. West Wind Management Group, Inc. with Christian Wiebert, Muller, and Graff. I have contacted newsrooms and reporters, of which I contacted all newsrooms in Denver, Colorado, and sent emails to Representative James Coleman, Leslie Hurrod, all Colorado news stations. I sent to Atlanta, Georgia news stations, Philadelphia, Pennsylvania, Detroit, Michigan, Montgomery, Alabama, Washington, D.C., emailed the 12 judges in the United States White House. President and First Lady Biden of the United States and the Attorney General of the United States, handwritten each of them 10 times or more, and certified mail from the U.S. Postal Service. No response until date. In 2008 through 2009, Christian Wiebert and Muller and Graff harassed myself from my hospital bed, of which a doctor wrote letter to the courts. I have documents. Christian Wiebert and Muller and Graff garnished my government check, of which Denver courts returned to account. You cannot sue the government. I have documents. Court filed notice for failure to prosecute. Alex J. Martinez, manager of safety, ex officio sheriff at City and County of Denver, state of Colorado, by Sheriff Sergeant G. Hill. Haven was in charge at the time of foreclosure, said he would resolve this matter. He was the sergeant that approved $9,600 from HOA Christian Wiebert, Muller, and Graff, not Sergeant Hill. Chase then, in 2012, hired lawyers Hush and Blackwell, found I did not owe what Christian Wiebert, Muller, and Graff, the amount of money was owed was only $200. I was already $100 ahead. I went to Stout Street Clinic for a lawyer. Kunta and Rock law firm could not help Eleanor Joyce Oliver because of conflict of interest. They worked for Chase. Violation of my rights. Abuse of power. Afflicting instability on my livelihood. Violation of my constitutional rights. Violation of my civil rights. Money laundering. violation of my constitutional rights of freedom of speech, to inflict psychic, logical warfare upon my psychic, and physically handcuffed and attacked me. Stalking, unlawful surveillance, intimidation in order to violate my constitutional rights, defamation of character. Title 18, deprivation of rights under color of law. Department of Justice, Section 242. Title 18 makes it a crime for a person acting under color of any law to willingly deprive a person of a right of privilege protected by the Constitution or laws of the United States. Title 18 U.S.C. Section 241, conspiracy against rights, makes it unlawful for two or more persons to conspire to injure, oppress, threaten, or intimidate any. What constitutes a violation of civil rights? Title 18, Chapter 17, Coins and Currency. Mutilation, diminution, and falsification of coins. 332. Dismacement of coins. Alteration. 331. Mutilation, diminution, falsification of coins. Whoever fraudulently alters, defaces, mutilates, impairs, diminishes, falsifies, scales, or lightens any of the coins at mints of United States or any foreign coins which are by law made current or are actual use or circulation as money within the United States, or whoever fraudulently possesses, passes, utter, publish, or sell, or brings into the United States any such coin, knowing the same to be altered, defaced, mutilated, impaired, diminished, falsified, scaled, or lightened, shall be fined under the title or imprisoned not more than 5 years or both. Historical revision notes based on Title 18 U.S.C. 1940 ED 279, March 4th, 1909. CH 321 165 35 STAT 1119. Mandatory punishment provisions was rephrased in alternative. Reference to persons causing or procuring was omitted as unnecessary in view of definition of principle in Section 2 of this title. Changes were also made in phraseology. Section 242 of Title 18 makes it a crime for a person acting under any color of law to willingly deprive a person of right or privilege prosecute by the Constitution or laws of the United States. Deprivation of the rights under color of law. Department of Justice. Example: lying on official documentation in order to make an arrest, order a warrant, or prosecute a case. What 3 things you cannot be deprived of? The Fifth Amendment and the 14th Amendments to the Constitution, which guarantee that no person shall be deprived of without due process of law, life, liberty, or property. Without due process of law, incorporated. The model of the rule of law. The English and American lawyers associated most closely with Magna Carta for centuries. Jurisdiction can be lawfully acquired. Jurisdiction cannot be lawfully acquired by fraud. Evidence of move of court to show jurisdiction on the record. Latin versus Hopper, 102 F2D 188. Chicago versus New York, 37 F SUP 150. Stuck versus Medical Examiners, 94 CO 2D 751 211 P 29389. Ramond versus Lambert, 469 F2 416. Argent Mortgage Company, LLC. Status: withdrawn formation. Date: 8/16/2001. Foreign Limited Liability Company, jurisdiction, Delaware. Westwind Management Group, Inc. Dissolved March 6, 2019, April 4th, 1986. I would like my case public knowledge. Case number 2021 CV 3327. Judges acting in this case: Judge Gertis, Judge Engelert, Judge Lay, and Judge Buchanan. Judge Alex Myers, which set trial date for the 14th and 15th of June 2023 for HOA default. Judge Sarah B. Wallace, acting judge now. Lawyers in this case: Holly Shilladay for Chase, Ree Van Mortel for Vanetta Bush Williams, M2 Lending Solutions. Ree Van Mortel withdrew December 28th, 2022. Sarah B. Wallace gave Vanetta Bush Williams until February 7th to find new counsel. She hasn't found new counsel unto date. We are supposed to be in trial by Judge Alex Myers, June 14th and 15th. Eleanor Oliver's information: 303-371-8962, 720-985-0944. Email oliver77@yahoo.com. Stay blessed, and thank you.